there is no any other complaint against the second respondent. And indeed, the petitioner, during cross-examination, this that actually she has no complaint on the 183 polling stations. The reading of Section 8 of the Parliamentary Elections Act requires a petitioner to have a legal grievance, and particularly in the reading of Section 80, 1A, that you must come to court to demonstrate that there was non-compliance with the Act. And the Act mentioned of my lord in the Parliamentary Elections Act. My lord, it is not enough to access this court glossing over all irregularities. It cannot be enough for a petitioner or any other person aggrieved to access this court without a legal grievance. Within the meaning of Section 80. The court has interpreted this section. My lord, I have two authorities. One was cited by counsel for the petitioner. I already have a copy which I have validated. One is Owebe James versus Electoral Commission and Israel Age, Wagahunga. Election petition appeal number 72 of 2021. I would invite you to read the judgment of Madram on page 17. My lord, I will suppose another thought of Jim Wise. My lord, Jim Wise is a High Court decision on page 112. Some effect of that decision, of those two decisions, is that there is a greater burden, or the petition carries a huge burden for which this one I report, that actually the non-compliance relates to the Act. With information, my lord, I will read what court said, that under section 61, Mathematics 80, 1A, it is very clear that the non-compliance has to be the provision of the Parliamentary Elections Act relating to the elections. That secondly, the court has to be satisfied by the failure to conduct elections according to the principles laid down those provisions, and the non-compliance with the rest in a substantial manner. The inquiry therefore has to relate to whether there was non-compliance with the provision of the Parliamentary Elections Act relating to elections. That presupposes, by law, that the specific provisions of the Parliamentary Act have to be set out to determine the non-compliance. If the first part of whether the preliminary action was not compliant with is not surmounted, then the second requirement of the inquiry is whether the non-compliance affected the rest in a substantial manner. Moreover, the petitioner has set out in his or her petition that specific provision that was not complied with. And when it is our case that indeed the second respondent complied with all the requirements of the Parliamentary Election Act and there was non-compliance. There was no any provision cited by the petitioner that the EC did not comply with any of those provisions. My Lord, I will take all those segmented complaints of the petitioner and indicate to you that actually the election commission complied with the requirements of the law. The first complaint, my Lord, of the petitioner is to be found in section 72. But your petition alleges that the second respondent never complied with section 72 of the Election Commission of the Parliamentary Election Act. My Lord, the gist of the petitioner is that the returning officer proceeded to tally the results of the 183 lot first receiving all the envelopes. And that's the gist of the petition. And the only chose to read only 72:1. He did not bring this one and report the contents of 2 and 3. And this is what 2 says. The returning officer may open the envelopes and add up the number of votes cast, even though some of the envelopes have not been received. If the candidate's agent and police are not below the rank of the inspector of police are present. The value does not shift to the second respondent. Prove that actually the agents of the petitioner were not in the 30 center. It is the petitioner to bring cogent evidence to show that the returning officer invoking section 72, her agents were not in the 30 center. That is it. Does it mean that the returning officer cannot tally, even though he has not received all the envelopes? No, the law says that actually he can proceed. 72:2. The only requirement that the returning officer needs to prove before he invokes 2 is to ascertain whether all the agents of both candidates and the candidate. Then the question, my Lord, to you will be, did the EC comply with this section? Is that still a complaint? No. And my Lord, this is not strange. This is not strange. In Amama Babazi 2016, Now that we're very copy, but I'm going to read the relevant extract at page assessment as being copy. Mark at page 141. The court was faced a similar scenario. My own the presidential petition number 1 of 2016. All of us counsel we are parties. We are counsel in that matter. But this is what court said at 141. On whether the returning office actually is close to his power, proceed to study before receiving all the envelopes. The Supreme Court had to say this. I'll read this, but I will get to the relevant. Furthermore, the petitioner did not adduce evidence to show that the declaration of forms were not filled by the presiding officer after the closing of the polls and counting of the polls. Neither did he adduce any evidence so that when the presiding officer opened the results, envelopes, before they received all the envelopes from their respective district, there was no police officer at the rank of the inspector police, and therefore all the candidates, all their agents, bearing in mind the constitutional obligation imposed on the evidence within 48 hours. Now, this is what captured the same scenario that you must go and prove this one I report that if you have a legal grievance under this section, prove two things. You do not have agents in the time center. That's number one. Number two, there was no police officer under that rank. Man, you cannot tie for life. That time limits within which you have to declare a winning candidate. So the petition is not at liberty even to abscond or to make his agents abscond from there. If one is missing, at least have a police officer. My lord, there is no such evidence that the petitioner was going to present to the entire center, and therefore this one cannot be a non-compliance. And that brings me to the decision that gave the grievance and interpretation of this act. My lord, this is the act. My lord, we are faced with the question then which other law did the second phase not comply with for it to sustain such a grievance. Then it brings me to a second bit of the complaint. That actually you're waiting for results. What happens? That there are no results. The procedure in the entire system is like this. And this is the sun. That when it takes place, it closes. The presiding officer fills the DIR forms, and the transmission process proceeds as such. Now, at that point at the tally center, the returning officer is receiving results. Now, this is what the law commands the returning officer to do. One, if you have an envelope and it does not have results, that is section 72.3. And I'm not invited to party. And this is a scenario that really happened. You are a returning officer, you are waiting for results. The envelopes are coming. If you go to the envelope and you can't find results, the direction to go to the report book. The law commands the returning officer look at the preserving officer's report book. Well, if you can't find it in the report book, the law commands you to go to the ballot box itself. My lord, there's a presumption that actually in those two, you'll find the results. The second thing the law recommended you to do is to reseal. The only requirement you need is again to have the other police officer at that rank. But it's the scenario. Now at that point, if you can't find those as a returning officer, right from section 72, is that the only option left to you as a returning officer is to declare. My lord, the law does not tell the returning officer to run away. And this takes you to what the petitioner's counsel was proposing, that actually what you are declaring are provisional results. No! These are not provisional results. I'm yet to be convinced by the petitioner in the brief set in my grandma's case, Ode's case, and Jim West, that the returning officer never complied with this section. The only option left is to declare as a returning officer. Another section, my lord, is what you write and noted yesterday in the case of dating Zani. Those exceptions. And I invite you to write in this case. Those exceptions that they gave. 2, if you are cut before. 3, if they are missing. And by the way, this section does not even impose a duty on the returning officer to inquire. No. It only commands him that now that you have suspected that you have all this, there are possible ways of where you can find the results. The vote book, the ballot box. After that, proceed to declare. And if you do that, you have not, that is not non-compliance. And my lord, we have been guided by the Supreme Court on such a command of the legislation in sit and several. My lord, this is the election petition appeal number 6 of 2009. It is not up to the suitors, the petitioners, to propose a sanction within the law or to amend it within the law. My lord, while the Supreme Court was dealing with Section 50 of the Parliamentary Elections Act, then it was on the other forms. My lord, in that case, that some users were declared on the woman, the dear forms of a woman, district woman member of Parliament. And the argument was that this was not a prescribed form. And what has this to say? That we observe the second phase of the Parliamentary Act which describes the procedure in regard to education of those forms does not prescribe what will be the effect or consequence of its non-compliance. It appears to me, and that is odd, that the section is directed in the sense that it directs how election results and paperwork collected here which should be done. Mere non-compliance with the state in the procedure will not affect the results. And the appeal was dismissed. And in my own, when you retire to write a judgment, you retire a look and address yourself to that decision. When you read section 72, it gives you the procedure. Like available here, it gives the procedure. That even if I agree with them, that actually was not compliant with that procedure. So long as the intention of the returning officer or an administrative body like Electoral Commission is achieved, it is not for the petitioner to say that has affected the results. And this is simply what my role. And it's also submission that my role, that in a given scenario, the petitioner cannot purport to say that EC did not comply with the provisions of tag and declaration. And actually, and indeed that was not provision does. And the question would be, then what would be the final result? And where do you read the provision results? My own the results of an election is to be in the return form. Under section 77 of the Private Elections Act. Whether that return form was properly filled is annexed to the petitioner's petition. So the process was complete. The tally sheet and the DIR forms of 183 polling stations, which translated into 92.7% of the registered voters of Kawai. That result represents 92.7% of total registered voters of Kawai. That now you are first to take a decision between 6%, representation of 6% for 7 vis-a-vis 92. The petitioner also had strange proposals and invoked the non-applicable section. But if I take into that matter, then in the circumstances, what did the returning officer after declaration as responsible as administrator of elections? What did he do? When you read the affidavit of the returning officer, I think it's paragraph paragraph 11. That the following day, the returning officer reported to police. CRB 350 stroke 20, CRB 350 Myron stroke 2025, and CRB 356 stroke 2025. Probably that's what an administrator or internal will do for them to investigate. The report was about the violence that was reported to him on the 14 polling stations. And I was thinking that to evaluate. Because like I just admitted, the electoral process is a progressive nature. You're already there. The law does not say go down. You're in the transmission process. You must first complete the tiling process. One would presuppose, maybe like the petitioner wanted, that please hold on to the envelopes you have, rush police, investigate. No. The flowing river principle applies. Finish the process, have the winner declared, then report the relevant authorities. And this is what the referring officer did. My lord, that fact by the petitioner has not been responded to in the rejoinder, has not been denied, simply been put. And as we speak, maybe the investigation is still ongoing. And that's what we can do as an electoral body, that we give the relevant authorities to investigate. That for you to suppose that you stay the entire process, you wait for the envelope under section 72, my lord, that is not tenable, and that is not a command of section 72 in the timing process. My lord, we take it the fourth complaint of the petitioner. Interruption. You coached the petitioner coached her complaint on section 76. Interruption, postponement, and counting tariff process. Madam, you're faced with a very peculiar situation. What this section presupposes is that actually when the violence erupts, you are given the time to prepare and safeguard the electoral materials. That's what it presupposes. That you hear noise, people are carrying stones, the mob is being organized, then the electoral body very fast secure the electoral materials for you to be able to postpone the counting. And by this is what comes out in the other evidence, supporting evidence. What is not in quotation is that the polling process was peaceful in the 14 polling stations. That measures had been taken by the second respondent to put all electoral materials in the press. Voters stand up in huge numbers to cast their vote. Polling closed at 4, with no major incident reported by the petitioner. Only other person in the electoral process. But from the evidence of the supervised or designated officers is that at the point of sorting, all those who have participated in the process, is that in this process of sorting, now the FARIDAH is here. Nalukoola, it is here. So the court is there. After that process of sorting, there is a heap here, there is a heap here. Now, the winner will be suspected. The ruler is suspected. And I don't want to be misquoted for me to say that maybe this could have been attributed to any of the parties. That is when the mob came in and smashed, destroyed the key electoral materials. And these are the key electoral materials. And after taking back section 72, because you cannot evaluate section 76 in this total disregard of section 72. What were the key electoral materials? One, the report book. Where the returning officers were elected under 72. Two, the ballot box. Three, the DRR forms. My lord, that is the process that the 14 points that was interfered with.
All those documents were
Destroyed. It's an act of God, maybe. But that's an act of Satan, because. But the man of God's man is responsible for this. And man benefited. But not to be different if the winning candidate gained a fair advantage. And how do you tell that you have gained a fair advantage? If at that point maybe the rest of other politicians had been done, that may be number one. You say maybe this one gained because he was losing, they be organized. And then of course suggestions for the other parties, none gain. My own person, a petitioner, cannot come to this court to take advantage of this act of Satan. To take us back to the polls. I know this is where I want to read that this court now he has been under Article Section 82, 5, rather 4. That persons were duty to inquire. What has intended the inquiry could be the evidence, and indeed it is this evidence, that before you take your decision, make a thorough inquiry. That are you going to give us a decision or a precedent that politicians or supporters of politicians, my lord, or politicians, my lord, or supporters of politicians will always organize themselves in a mob to interfere with the process to access this court? It is a precedent that we are going to look for. Moreover, in a situation where none of the parties benefited, my lord, we have got it from supporters that actually all politicians, be it winning, be it losing, are desperate to win. And that's why court, in one of the authorities, submitted that even when they are evaluating the evidence, is that you have to give it the care, attention on that. But no, it calls for wisdom from the presiding judge. That you do not want to have a judgment that is going to set a precedent that supporters can interfere with the work of the electoral body, to fail it to declare, or to use it as a vehicle for a by-election. And why by-election I say it calls for wisdom? Much as I'm a lawyer, I've been forced, my lord, to get one of the interesting verses of the Bible in making a decision. That is 1 Kings chapter 3, verse 3:15. And my lord, this is about the story of King Solomon. We are all familiar about that story. When he was confronted with a child, and the child is Kawempe, and he said, now what do you want? The other person said, kill. I'm not reading the petition, I don't want to discuss it. The judge said, no. My lord, you need that wisdom. Because this death only calls for wisdom. But my lord, also bothers you that at cross-examination of the petitioner, she says, I couldn't get 100 in the 14 polling stations. Yes, I could win in some, but I could not get 100. And that's why I was, then what? You don't want to be declared? You don't want anybody to be declared? Where is our child? So, under the inquiry, my lord, that is an area that you revoke the first king, Solomon, for your decision. Then, my lord, after taking all those alleged non-compliances, and having convinced you that actually none of the provision was not complied with, and indeed, there is no section of the law that has been pointed, there is no evidence to that effect, this way there is non-compliance. As for petitioner, at least not the petitioner, proposed that's why they didn't postpone and count. I've already submitted this one in court. That was impossible. Even if this court directed today to conduct election, I don't know what it will be, in the 14th. It is not possible, my lord, and the principle of adult suffering. Even if it was the following day, it is not possible for the electoral body to have even to propose to have elections in the. Why, my lord? Is at the timing of the mob had frustrated or had an effect on the entire constituents. Why, my lord? And this is what I'm submitting. One, that the results of other polling stations are already been announced, and that has an effect of the proposed election, the 14th. So the body itself, the second one, would not. And simply, none wants at times that the majority want to associate themselves with the losing candidate. So the results in other polling stations would have an effect on the 14 polling stations. So that is not even possible. So one, you can't order for or postpone elections or repeat elections because the already declared results of these other polling stations will have the effect on the 14th. And it's simple principle. Because under this election, that even one voter can make a difference, and that is not available. So, counsel for the petition and this proposal for that. What were the rush? No. That even if it is today, you can't have that election without it. My ordinary, after convincing you that was no non-compliance, I would swear have stopped that. But if you're inclined, my lord, 5N is onward. The framers of the law never anticipated that you are going to have an excellent election. And that's why they say the family to be free and fair. Not excellent and exceptional. No, these are weddings. That's the number one. Number two, that actually it is not enough to annul. It is not enough to annul. That non-compliance must be substantial. So you have a huge burden as a petitioner. That will test my role. And to appears to the petition only on the numbers, on the other test. On the quartet. And this is why our point of departure is. I really associate myself with the principles of the law. In as far those authorities are applied to my law. But only the part where my lord, and I must approve Mr. Kabule, that when he gave some judgments, he picked those that favored him. The portion of the judgment. But you need to. I refer to one of the judgments, my lord. A change our opinion. The Court of Appeal, it was applied by him. And my lord, I'll refer you to page 21. I'll give you my copy as well. What did we consider? My lord, counsel for the petitioner omitted the good way it is to bring this fact or principle to you. This is the authority that by a judge have compared the aggregate number of registered voters from the 17 polling stations of 8,144 together with the reading value of the first appearance, and then conclude by washing away the first appearance in my winning majority. Now this is what he wants you to do. This approach overlooks the fact that each candidate at this election suffered equally from the decision of the Electoral Commission to exclude the votes from the 17 polling stations from the final tally of the rest. My lord, there's one thing. In fact, here, the electoral commission had admitted. Here we didn't even admit that there was none to admit. I'm just bringing with all the decisions that were supplied by counsel for the petition. And the only distinguishing factor, my lord, is that in all those decisions, there were results. And really at this point, I should distinguish them. There are results. That's number one. Number two is that in all those decisions, my lord, the writs had been tampered with in terms of altering them, in terms of returning officer deliberately not including them in the direct favor of the other candidate. But more interesting is that in those, the margin was very slim. I invite your lordship to look at them as well and be able to deduce the fact that indeed they are not applicable. My lord, the court, after faulting the trial judge, they went on to say the respondent therefore had to decide the value that she should have got the majority votes if the votes from the 15 polling station are reflected in the account. She had the requisite evidence to prove or disapprove this. She did not abuse it, and thus she failed to discharge this burden. So, my lord, all along, what counsel for the petitioner was to invite you to consider the 16,640 registered voters vis-a-vis the difference, which is 8,000 plus. My lord, this judgment, which is supplied by himself, says no. That is not the formula. That you cannot give here and wash away. Because you owe the petitioner, the respondent, you suffered equally. My lord, this is submission of course. There's a couple of paper, but it highlighted the very part he wanted and omitted the part we want you to rely on, my lord. My lord, this court counsel for the petition is applied with a judgment or election petition number 56 of 2021. Electoral Commission appearance versus Mosuku Jacob. I also want to distinguish. I want to distinguish this judgment. One, that it is not applicable in the trial of parliamentary elections. This was the local government case. And if my lord, I'm saying it is not applicable, and I'm supplying you with this authority that it's confined such a decisions from being relied on by this one I court trying and implemented to that. And it's very simple, my lord. This decision is
Let's explain why you say. Let's explain why.
Yes. My lord. The dilemma discussed in the case of Maputo Augustus, this election petition number 73 of 2016, versus Western David and the Electoral Commission. It is not a my lord, one, Scott of Appeal, my lord. One, and this is where I was driving that, because of the different standard under section 80. My lord, the standard under Parliamentary Elections Act and the local government is different. And without labeling, I'm going to read you the extract, the decision of the court. Most especially the one of criminal. But in that, my lord, if that court had wanted to purport to invoke, I know the equivalent section now, by then to have 172, to apply the provision of Parliamentary Elections Act, to apply local government. Court said no. The standard is of balance of probabilities, it does not exist in local government, my lord. What you are required to prove is satisfaction of court. In the decision that was submitted to you, the standard was different. Satisfaction of court. My lord, here, as well as submitted by counsel, and he took the different decisions on the balance of probabilities, it is not available in a trial of a local government petition. I submit. My lord, even if you have to borrow principles, like your lawyer wants you to do, it will still be distinguishable. In the sense that, my lord, there were results. In Mosoko, there were results. My lord, here, there are no results. And it's explaining. In that one, the margin was very minimal. And to be very exact, my lord, was less than 100. So, my lord, you that and the principles are not applicable. My lord, you also surprised with the authority of budget. It's also a submission. It cannot apply. It's in budget. Like I said, there are also results. But interestingly, in budget, in the tampon station returned 100%, and was doubtful. So as you evaluate it, you find out that in budget, there was evidence adduced that actually some people had traveled, some were dead, some came up to say, I never participated. They should have. Therefore, would you get 100% in the polling station? The scenarios are different. My lord, you're faced with a unique scenario. Which cannot be resolved by the principles in those cases. I don't counsel has given that, my lord, we submit that the second respondent did organize the fair and fair election. The declaration of the count of the first respondent was based on the majority vote, and that is to say 92%. That would be unfair for the 7% to influence and to be put my lord that the 16,400 640. And it remains 180 registered voters that my lord has going to submit the petitioner has failed to discharge his duty. When this one I report, which act of the parliamentary was not complied with. And those cited that he glossed over, there's no evidence supporting them. My lord, I have to write a report. And my lord, you'll be pleased to dismiss this petition. My lord, with costs regarding and that's a definite that actually his interest is not in this petition itself. That my lord will be our cost. Submit, my lord. Thank you.
My Lord, good morning. I'm a Lord for the record, Alex Muganda. My Lord, for the first respondent, our submissions in reply will be structured and we shall flow the same way we did for the proceeding. We'll have 5 of us handle the different issues that we handled. However, for the preliminaries, I will briefly make a response to the preliminary objections that were raised by counsel for the petitioner, after which I will take leave and senior counsel Babazi will come on later. My Lord, there were basically 3 appeals that were raised. The first one, counsel for the petitioner is asking courts to strike out number of affidavits sworn in support of the answer to the petition on the ground that they are predated. My Lord, I would like to briefly submit that the preliminary objection itself is misconceived and not grounded in law. The preliminary objection itself is misconceived and not grounded in law. Because Rule 8.1 of the Parliamentary Elections Interim Provisions rules that counsel cited in support of the criminal objection does not talk about predating, nor does it talk about when. Nor does it talk about when the various affidavits in support of an answer to the petition should be dated or drafted. My Lord, Rule 8.1 referred to above is to the effect that upon being served with the petition, the respondent should within 10 days file his answer to the petition with the accompanying affidavits. And my Lord, what the petitioner's counsel is doing is the father of the house leaving the dining table and going into the kitchen, and is complaining that you have put the salt before the onions. My Lord, within the 10 days that the respondent has under Rule 8.1, he is expected to gather his evidence in those 10 days. So if you have a number of allegations against several people, whatever day you get them in the 10 days is fine. What the law requires that when you're filing, all these must accompany. Now there is no evidence on record, my Lord, that any of the affidavits that is complaining about was filed in court before the respondent's answer. What we have on record, my Lord, is that the answer, together with all the evidence and affidavits, were filed on the 24th. Were filed on the 24th. So, my Lord, before the 24th, when the filing of the respondent's answer was done, there was no answer. Neither court nor the petitioner would be able to tell whether there is an answer. We can only talk about an answer under Rule 8.1 when it is filed. And my Lord, there is no evidence on record or adduced by the petitioner to show that there were any difference in filing dates of this answer. And it cannot become an answer when it is still in the lawyer's chambers. So what counsel is looking at is the kitchen affairs. He peeped into the kitchen. But what we are saying is that under Rule 8.1, you wait for the food at the dining table. And it came to the dining table on the 24th. And my Lord, precisely, there is no issue as far as those affidavits are concerned. And we beg that the court be pleased to overrule the objection. But my Lord, in the alternative, even if we are to say that there was a problem in putting salt before tomatoes or mixing them up, my Lord, one of the authorities that was supplied by the petitioner's counsel under volume 3, my Lord, in the bundle, that is Muhindo. Rema versus Winfred Kiza, my Lord, on page 886. On page 886. My Lord, that's volume 3. My Lord, Lord, that case citing the Supreme Court decision of Colonel Kizabesige and Yoel Museveni, that is number 1 of 2001, on page 886 of the bundle. The Supreme Court held that the court should take a liberal view of affidavit petitions, considering the tight time schedule under which they have to be compiled, unless the omission is material and going to the root of the substance of the affidavit. My Lord, when a respondent is served with a voluminous petition of over 1,000 pages, with a periphery of allegations against everybody in every corner of the constituency, it is not possible, as counsel would want it to appear, that you collect all these people, they leave all the work they are supposed to do, so on the final day when for you are doing your affidavit is when you should now start getting their evidence. No. And what we have been doing in election petitions, the moment you are served, you get a number of lawyers, and each lawyer handles different people. Respond, respond, respond. What is important is that when you're filing, you must file on the same day. So it's not that whoever prepares evidence, they file it not. And when they are all going, they go in support of the petition. And that's what Muhindo and the Supreme Court is saying, that we should not be very strict on those issues. My Lord, on the other objection, which was addressing the issue of annexures, on the issue of annexure, my Lord Counsel took at length to impeach this particular annexure, and we, on observation of the same, note that this annexure was intending to support evidence on the total number of registered voters in the 14 polling stations vis-a-vis the total number of registered voters in the constituency. And this is a document, as alluded to by the first respondent, had been obtained from the Electoral Commission. However, with the hindsight that the same evidence has been adduced by the petitioner in the tally sheet and in the attached voters' rolls for the 14 polling stations, my Lord, we would concede to this on that annexure. My Lord, is one, which is the parking list, but its complex, it has not been marked. Annexure A to the affidavit of the first respondent in answer, in support of the answer to the petition. So we can concede to that because that evidence is already on record. But it can be done away with as prayed. My Lord, the third and last appeal that was raised was in respect to the affidavit of Nabakosa Rita. My Lord, it was the submission of counsel for the petitioner that Nabakosa Rita's affidavit did not comply with the requirements under the Commissioner for Oath Act. But it's our submission briefly in response, my Lord, that counsel for the petitioner's submission is unsustainable because he does not lay a sufficient background. He doesn't lay a sufficient background upon which such a prayer can be made. My Lord, when you look at the affidavit of Nabakoola, it fully complies with the requirements of the Oath Act. It was duly commissioned by an authorized officer. My Lord, under cross-examination, the witness before court told the court that she appeared before the Commissioner for Oath. She also told the court that they explained to her the contents of her affidavit. She also told the court that after explaining, she got her copy and read it. She also gave evidence that she swore. And the only question which the counsel for the petitioner put before her is whether there was a book. In cross-examination, whether there was a book, was there a book? And it remained vague as that. My Lord, when you go to section 5 of the Oath Act, the requirement, the main requirement, and this has been demonstrated in a number of authorities, is that the deponent must physically appear before the commissioner. And the deponent must understand the nature of oath she's taking and what she's swearing onto. My Lord, all the cases, including John Baptist Kapoza, that were supplied to this honorable court by counsel for the petitioner, in all those authorities, my Lord, the deponents did not appear before the Commissioner for Oath. Did not appear before the Commissioner for Oath. And my Lord, that is conduct that the Supreme Court was condemning. That is conduct that the Supreme Court was condemning. And my Lord, that is distinguishable. And that is distinguishable on how the oath is taken, the mode of taking the oath is a detail. Under section 5(2) of the Oath Act, it can be by Bible, it can be by Quran, or any other custom or mode acceptable. Because we have people who don't even, they are Christians, but for them when they are swearing, they don't touch the Bible. And that is them. Others will only put their hands up. So it's not about a book. Even a book does not mean a Bible. A book can be a book as a book. And that's the only question which counsel asks. So it is very insufficient to lay a background for a PO, as counsel would want court to believe. And finally, counsel made an alternative prayer. Counsel made an alternative prayer that if court is to agree, with him and strike out the affidavits, of Nabakoola then even her testimony on oath in court should be expunged, should not stand. My Lord, I would associate with the same if I was the petitioner also. Unfortunately, that's not what the law says. And that's not what courts have held. So one, for the record, we do not agree that there was any non-compliance with the oath or the Commissioner for Oath Act. But even if there was, which isn't true, the Court of Appeal, my Lord, in the case of Mugema Peter versus Mudiobola Bet Nasa, we shall rely on this authority later on other issues. My Lord, that is Election Petition Appeal number 30 of 2011. My Lord, in that authority where I happen to be a party, this time not as a lawyer, but as a witness. How do you deal with viva evidence? The evidence that the witness gives here. In the event that the affidavit is expunged, which cannot be done in the current circumstances for the reasons I've given, you also ignore the evidence that a witness gives under oath, and that this oath the same as the first oath that was taken before the commissioner affect this oath when the witness comes to court. My Lord, in that decision before you, I also encourage my brother to read there. My Lord, page 17. Under paragraph 10, my Lord, the court talks about how evidence should be given here under section 58 of the Evidence Act in these election petitions. When the witness comes here and takes oath, they are treated the same way we treat them in civil proceedings. That's why the moment she comes here and takes oath, they are cross-examined on what they saw, what they did, what. My Lord, on 17. Yes. Section 58 of the Evidence Act. Yes, my Lord, I'm flowing there because on the following page where I'm going to take you, court comes back. So I wanted to just highlight the background. My Lord, when you go to page 18, my Lord, in this case, where I happen to be party, the evidence of one of the witnesses, the respondent's witnesses, was struck out because it hadn't complied with the Commissioner for Oath Act. Through cross-examination, it was discovered that the witness did not appear before the Commissioner, and it was the witness's evidence himself, Reverend Indanda, that he hadn't appeared before the Commissioner. And what did the court say? I conclude, I've highlighted that part, my Lord, on page 18. On the basis of section 58 of the Evidence Act, and on appreciating the above legal authorities on the point, that evidence given to court on oath viva voce, like what Namakosa did here in court after taking oath, under the supervision and the superintendence of the presiding judge, is proper and valid evidence that the court must consider. And my Lord, that closes our response to that primary objection, that both limbs of the objection in respect to Namakosa's affidavit cannot be legally sustained. And the petitioner's counsel did not lay a sufficient background for raising the same. Most of life. My Lord, I'll take leave on that and request our colleague handling issue one to take it.
Issue number 1, my lord. The affidavits of, it was torn down to the affidavit of Ben Interruption. For the record, my name is Eunice, I never was there. My lord, I'm submitting in respect to issue number 1, whether the affidavits of Chamber Nathan, Maumbe George William, and Ben Mukasa in support of the first respondent's answer to the petition are legally admissible. Which issue, my lord, has since been whether the affidavits originally it was whether the affidavits of Chamber Nathan, Maumbe George William, much of that, my lord. Whether the affidavit of Ben Mukasa in support of the first respondent's answer to the petition is legally admissible. My lord, counsel for the petition has submitted that the affidavit of Ben Mukasa should be struck off because he procured witnesses, George William Maumbe and Chamber Nathan. He says that the affidavit, that the witness participated in an illegality and should not be allowed to continue participating in the proceedings, my lord. But my lord, there is nothing illegal about the affidavit of Ben Mukasa. It fully complies with the Commissioner for Oaths Act. It complies with the Oaths Act, and it was deemed read by court. My lord, also the counsel for the petitioner had an opportunity to cross-examine Ben Mukasa, and he conveniently disregarded that opportunity. He did not even make a prayer to cross-examine him among the people that he wanted to cross-examine. But now he wants to turn around and make presumptions and allegations and submissions from the bar about a supposed illegality. My lord, even when you peruse the affidavit of Ben Mukasa, it is only in paragraphs 10 and 11 where he makes reference to one of the expunged affidavits of George William Maumbe. But even as he's making a reference to that affidavit, he only says that he had an opportunity of perusing, of looking at that affidavit. And that is all he speaks about concerning the expunged affidavit in support of the first respondent's answer. He makes no mention whatsoever of the affidavit of Chamber Nathan. But most importantly, my lord, which is a well-known fact by now in these proceedings, these two affidavits have since been expunged. So it is our submission, my lord, that we cannot have a conversation about procuring witnesses, about the action being an illegality when the purported procured witnesses no longer have any evidence on the record. My Lord, what counsel is trying to do is to sort of raise the dead. And I think it's important that he lets the souls of the departed affidavits to rest. My Lord, counsel's submission about an illegality, the decision he has furnished to the court, all that is evidence from the back. There's totally no illegality. Totally. And to expunge Ben Zale's affidavit in support of the first respondent's answer, my Lord, is to deny both the first respondent and even Ben Zale Mukasa a right to be heard. It's against the tenets of a fair hearing, my Lord. The affidavit, Ben Zale Mukasa was accused of several acts of bribery by first the petitioner. These are fortified in the affidavits by the affidavits of Wanjala Solomon, Maumbe George Williams, Chemba Nathan, and all of them are accusing him of committing different acts of bribery. He should be allowed to defend himself. He should be allowed to respond, my Lord, which he has done and filed an affidavit which is already being read by court. My Lord, our prayer is that if it pleases court, only the two paragraphs, paragraphs 10 and 11, only three paragraphs, my Lord, 10, 11, and 12, with the affidavit of Ben Zale Mukasa be severed. From his affidavit. My Lord, severing portions of paragraphs from an affidavit is not removable. In the case of Kiza Besige versus YKM, the presidential election petition of 2001, cited with approval in Mutembuli Yusuf versus Nagumu Moses Musamba, at page 16, my Lord, an extract from the judgment from the holding of Justice Mulenga observed that in my view, a court can reject offending parts of an affidavit while accepting the rest of the same as it rejects inadmissible oral evidence. My Lord, we pray that only paragraphs 10, 11, and 12 be severed in the affidavit of Ben Zale Mukasa. And the rest of the affidavit be useful for this court in evaluation of evidence, my Lord. Much obliged.
I'm going to submit on issue number 2 in relation to the factual arguments that will be bad. And running back in, they will buttress them with the law, the case. So now you do the fact.
Okay. So, Mr. Boss, let's take a short break.
No problem.
Let's review back to 11.
Koti muda dakika 10. Oli live ku Shalom Television Uganda. Amala kusaka microphone tunyemu dakika 2. Ahora le gusta usar el mkoa. Mali? Oli live ku Shalom Television Uganda mugamba mutemanya tabira nabo Trisha Keller. Aha, teka di pronounce bulungi. Aha, Kakoza Isa ogamba otya? Tads ogamba otya? Ibrahim ogamba otya? Lydia ogamba otya? Namwe n'abagiriko tukyagenda maaso ne kooti ya council Nalukoola.